When talking about privacy, people tend to use certain terms. Let's define a few. Here's a dictionary definition of privacy. Broadly, privacy is the right to be let alone, or freedom from interference or intrusion. Information privacy is the right to exercise some control over how your personal information is collected and used. Personal information is information about an identified or reasonably identifiable individual. It doesn't matter if the information is true or not. Some personal information examples, like an individual's name, signature, address, and telephone number. It can also be their date of birth or their bank account details, and even an opinion about a person. Sensitive personal information is a special type of personal information. Stricter legal obligations apply. Examples include health data, racial or ethnic origin, political opinions, sexual orientation or practices, also criminal record and certain biometric information. Have you heard the term an APP entity? It refers to those agencies and organisations with Privacy Act obligations. Almost all federal government agencies are included, but not state or territory authorities, or, oddly enough, not registered political parties and their representatives either. Medium and large private sector organisations are also APP entities, mainly because their annual turnover exceeds $3 million. Small business operators, comprising over 90% of all Australian businesses, are usually exempt. However, there's some small business operator exceptions, where the Privacy Act defines them as an organisation, so they're then considered to be an APP entity. For example, small businesses providing a health service and holding health information, though not health information held in an employee's record, or a business disclosing or collecting personal information, say selling contact lists for direct marketing purposes, or an organisation that's paid to collect information about an individual's political preferences. So, who has Privacy Act responsibilities? Must every business conform with the Privacy Act? Well, no. The minimum annual turnover threshold level is $3 million. This exempts most Australian businesses from Privacy Act compliance obligations. But if a small business handles sensitive personal information, then it must comply. What are the main kinds of organisation required to comply? Top of the list is Australian private sector health service providers. This includes private hospitals, day surgeries, medical practitioners and pharmacists. It also includes complementary therapists like naturopaths and chiropractors. Gyms and weight loss clinics must also comply. In the education sector, it includes childcare centres, private schools and private tertiary educational institutions. Privacy Act obligations also cover businesses trading in personal information, plus those businesses choosing to opt into the Privacy Act. The Act also addresses certain business acts and practices, imposing obligations around money laundering and counter-terrorism, and for those operating residential tenancy databases, or conducting protected action ballots. Some types of organisation have specific obligations for dealing with personal information. For example, organisations involved with consumer credit reporting, those dealing with tax file numbers, TFNs, or spent criminal convictions, plus organisations involved with the Personal Property Securities Register. And of course, organisations handling personal health information. It's quite a long list, but you might need to dig a little to determine whether your particular organisation has specific Privacy Act obligations. Okay, what about the flip side? Who doesn't have any Privacy Act responsibilities? The Act doesn't cover individuals acting in a personal capacity, so neither you nor your neighbours have any personal Privacy Act obligations. you can keep lists and information about people if you want, providing they're for your own use in a personal capacity. Small businesses aren't covered by the Act unless one of the exceptions I've mentioned earlier applies. Other organisations not covered include state or territory government agencies. For example, public hospitals and healthcare facilities, though state or territory privacy legislation likely applies. Public schools and public universities, but not the Australian National University, ANU. In some circumstances, the handling of current and former employee records. Media organisations acting in relation to journalism, though the organisation must commit to observing published privacy standards, and registered political parties and political representatives. What about penalties for non-compliance? Well, that depends. For a civil penalty, i.e. for a serious or repeated privacy interference, the largest penalty is 2,000 penalty units. Currently that's $420,000. For a company, the largest penalty is 5 times the civil penalty provision, i.e. $2.1 million. Since 2017, a federal penalty unit is $210. From 2020, it's indexed. The Australian government plans to increase penalties to 10% of a company's turnover, or $10 million, or 3 times the value of a benefit obtained through information misuse. It also intends to provide the OAIC with new infringement notice powers, plus new penalties of up to $63,000 for bodies corporate and $12,600 for individuals failing to cooperate with efforts to resolve minor breaches. But for most APP entities, the real cost is fixing the breach and dealing with the consequential reputational damage. OAIC imposed penalties are rare and awards paid to complainants are relatively small.